Computer. All right, that should be working. So, hi everyone, welcome to today's F1 Doctors Immigration and Visa webinar. Today, we have the pleasure to invite three outstanding attorneys to speak with us to kind of introduce how, as international medical students or, people, medical students who are studying in the US, how do we navigate through the visa and immigration process. So before the webinar starts, I have to read a disclaimer because we are a volunteer organization. There's certain things that we're not experts on, so I have to read this real quick. So we are F1 Doctors. We are only a volunteer organization and we're a nonprofit, and we have no expertise and do not offer legal advices. Today's session is only purely for educational purposes. And if you have further questions from today's webinar, feel free to reach out to our outstanding speakers today, and I think they'll be more than happy to help with you individually. Just want to make that clear. So I'll pass on the mic to our great speakers, Ms. Welsh, Ms. Desai, and then Ms. Cronin. If you guys would like to take turns to introduce yourselves, that'd be nice. Anyone can start first.
I'll jump in.
Yeah.
So I'd just like to thank you for inviting us to speak today. So we actually work at Iandoli Desai Cronin. It's an immigration law firm located out of Boston, and we represent a lot of hospitals, research organizations in the New England area, so are well familiar with helping physicians and medical residents and everything go through the non-immigrant and even green card process. So we only focus on US immigration law. That's the only type of law that we practice. And so, I have been probably practicing now for close to 20 years and solely in immigration. And I'll let Prasant and Madeline introduce themselves.
Great, thank you, Mary. Yeah, I'm probably the elder statesman here. I've been practicing since 1992, so over 30 years at this point. And my practice focuses heavily on physicians. Once you're finished with your residency and get an attending physician, then your potential employer will call someone like me or Mary or Madeline to help with the immigration processes.
So my name is Madeline Cronin, and just like Mary and Prasan, I help physicians and other professionals that wish to work and stay in the United States and working for various institutions and companies, and that's what our firm does, and had next year 30 years of experience. So it's great to present to you all, and thank you for attending tonight.
All right, great. Thank you for introducing yourself. So would you like to start sharing the screen and start the presentation?
Sure. You do that. Let's see. Okay, can you see it?
No, I think.
Not yet.
Yeah.
Or no?
Still no.
No.
Okay.
Oh, there we go.
Oh, now you can see it. That's my favorite place to eat. So
That came up a lot, Prasan.
Right at dinner time. I'm hungry.
Yeah. All right. So now you can see it, correct? Okay, great. All right. Well, thank you so much for having us. We introduced ourselves, so we'll skip over this nice screen. And just like Kevin, we'd like to, have a disclaimer before we start. What we're presenting is educational in nature, just like Kevin said. And by having this presentation, we do not intend to create an attorney-client relationship with you all. The purpose of this presentation is to give you some information about the U.S. immigration system and the opportunities it has for physicians like yourselves or would-be physicians in the near future. And so the information today is current as of today, but the immigration law is pretty dynamic, so it does change. And so there could be policy developments in the next few days or next few years that could change your options. So before you undertake any kind of path, make sure to consult with an immigration professional. So today we're basically going to talk about, give you an overview of the U.S. immigration system, discuss some key concepts, go over the J-1 visa waiver program, because many of you, even though you're at F1 now, many residency programs or try to get you into the J-1 program, and eventually you'll need to get a waiver of that if you want to, extend your career in the U.S. So we'll have many slides on that. And then Mary's going to talk about temporary work visas that are available. And then Madeline will end it with a discussion on green card options. So again, like I said, this is an overview. And before we get into it, it's good to understand the way the U.S. immigration system works. It basically divides the world into two. You have U.S. citizens and you have everyone else. And you're on that side of non-citizens. So in the non-citizen category, we have different levels of it, or different types of people. We have permanent residents, people with green cards. Those folks can stay in the U.S. permanently and work in pretty much any lawful job. But it's not, usually once you have your green card, after 5 years and sometimes after 3 years, in some cases, you can apply to become a U.S. citizen. So just because you have a green card, it's not, the ideal situation. You do want to become a citizen eventually. That way you can vote and participate in the civic life of the country. But usually for non-citizens, we have the green card holders, then we have non-immigrants, people like yourselves, people on F1 status, on J1 status, and there's about 80 different statuses out there. Many allow for work and many don't. And Mary will talk about the statuses that allow for work. Also, we have humanitarian people here on humanitarian grounds, so people with refugee status, with asylee status, people with TPS, which is a temporary status, and then we have parolees. You might have heard of the recent parolees from the Ukraine, also parolees from Haiti and Venezuela are going through a process to come to the US. Again, these are humanitarian grounds. And then we have a whole lot of people without a status. And some of these folks are individuals who came to the US on a proper visa, but then did something to violate their status and became, and now are without a status. And then we have a whole group of individuals who come to the US without inspection, and those people are here without a status as soon as they arrive. So that's kind of a quick overview of what the system looks like. Now, there's some key immigration concepts that you should be aware of before we get into the nitty-gritty of the U.S. immigration system. First, it's important to recognize that the visa you have in your passport is issued by a Department of State, and that is an entry document. It doesn't govern your stay inside the United States. Now, you do need the visa to come to the U.S. and ask for admission, and you ask for admission in front of Department of Homeland Security. And the Department of Homeland Security, they have sub-agencies within it, Customs and Border Protection. Those are the folks at the border and at the U.S. airports, and they allow you to make an application for admission, and they admit you into the United States in one category at a time. Now, when you are admitted into the U.S., make sure to check your I-94. That is an electronic document that's available at the CBP website. So once you come into the U.S., make sure to check that I-94, that it's in the right category, and that you have the right amount of time next to it. So if you're in an F1 status, which most of you probably are, you should be admitted in F1 and for duration of status, so D/S. So that should be on your I-94. If it's something else, then you have to contact your DSO immediately to get that fixed. We often see this problem if you have, let's say, multiple U.S. visas in your passport. If you have a F visa or a B1 visa, if you get admitted as a tourist instead of a student, that could cause major problems on your eligibility for OPT and your changes of status later on. So make sure to check that. Now, once you're in the U.S. in a particular status, you can apply to change your status. And that application is made to USCIS, U.S. Immigration and U.S. Citizenship and Immigration Services. That's a sub-agency within DHS. You can also extend your status in the U.S. For both change of status and extension of status, there are limitations. Not everyone is eligible to do those things. And it really depends on the particular status you're trying to get to and the status you have right now. Now, these are the principal visas used for and by physicians. So the F1. So once you are in medical school and F1 status, at the end of your studies, you should get 1 year of OPT. It's not guaranteed, so you have to work with your school to make sure you qualify. But once you have that OPT, you can start a residency program on that. There's the J1 visa. We'll talk about that in a second. That is the principal visa used for training purposes in the United States. So even if you desire to get a different type of visa, most programs will funnel you to the J1. And that's just unfortunate, but that's the way many of these residency programs and fellowship programs operate. They want everyone in J1, but that's not required. And so every program is a little different, and some programs will allow for sponsorship under H-1B, which is a terrific visa status to have. The H-1B one is similar, but it's limited to Chile and Singapore. The E3 is also used sometimes for training purposes, but that's only used for Australian citizens. Now the TN I list here, but it's not really available for clinical physicians. If you're a physician from Canada or Mexico, you can come to the US to do research on the TN, and some programs will allow you to do that. But basically, if you're in a clinical residency program, TN is not an option. The O1 is available, and Mary will talk about that, and it's for persons of extraordinary ability. It's extremely difficult to get, but it is there, and there are unique uses for that program, and sometimes you'll qualify for it. Now, like I said, most of you will have to go through the J1 program, probably 90% of you, and that's the workhorse visa for training purposes. Now, the J1 generally doesn't require you to go home for 2 years, except if you're in a clinical, as a physician in a clinical program. All physicians, no matter what country you're from Canada, you're from Mexico, you're from India, if you're in a J1 program for clinical training, you will be subject to the 2-year home residency rule. Now, if you have been here before on a J1 for research purposes, you might be subject to the 2-year home rule because your government, either your government or the US government funded your training here, or if your country is on the skills list. So if you're doing medical research and you're from India, you're going to be subject to the skills list. But once you transfer to a residency program, you'll be again subject to the 2-year home residency requirement. Now, what that means is that if you are subject to the J1 2-year home residency requirement, that means that before you can get a green card or an H-1B, you first have to spend 2 years in your country of last permanent residence or nationality before you can get one of those statuses. So it is a requirement. Now, if you have a J2 spouse or children, they also will be subject to this requirement. And so then the issue comes up. If you're finishing your training on the J1 and you don't want to go back home, what do you do? And that's where waivers come into play. So the waiver process, there are 4 grounds of waivers generally for the J1, but there's only 3 available for physicians who've gone through the training programs here. So one is through a request by an interested government agency. Another basis is hardship to a US citizen's spouse or child. And the third is persecution. So I'll go through these, in order. Now, typically, to get an IGA, an interested government waiver, the first step is to apply to Department of State for a waiver recommendation application. once you have that, each IGA program has different requirements. They're all very similar, but there are significant differences also. But then you apply to the IGA for a recommendation. Now, once the IGA makes a recommendation and accepts you and basically nominates you for a waiver, it goes to Department of State. At Department of State, they look through your entire history to make sure they want to recommend you for the waiver. If they recommend you for the waiver, then USCIS is the final authority and grants the waiver. And I've never seen a case where Department of State has recommended a waiver under the IGA basis where USCIS has not approved it. So if you get Department of State to recommend the waiver, 99% of the time, you're going to get that waiver. Now, once the waiver is granted, then you can potentially be re-subject to 212E, which is the 2-year home residency requirement, if you start a new program, a new J1 program. So if you're in this process, you're going to be most likely represented by counsel. Make sure to keep them up to date on what your plans are. And for sure, if you're in the waiver process, you do not want to start a new program because you could become subject again. Now, once you get that waiver, the natural course is for you to get what's called an H-1B visa status. And Mary will talk about that later on. But what I'd like to do is just to talk about some of the IGA waiver programs available for physicians. So this is at the end of your J1 training, basically. And there are 4 main IGA processes available. There's the Conrad 30 program. The Federal Department of Health and Human Services also has a program for waivers. The Veterans Administration has a program for waivers. And there's other kind of quasi-governmental authorities that also can nominate people for waivers. And they're the Delta Regional Authority, the Appalachian Regional Commission is another one. There are others out there, but these are the main players. And out of all of these, the Conrad 30 program is the most popular. And so we'll talk about that in detail. So each state can act as an interested government agency to nominate you for the waiver. And each state has 30 waiver slots. Now, generally, if you want to participate in this program, you have to sign a 3-year contract with a facility that is physically in a designated federal shortage area. Now, there are exceptions to this, and each state can nominate up to 10 or reserve up to 10 slots for individuals who will work outside of those shortage areas. So that's called the Flex 10 program. But generally, if you're in the Conrad 30 program, you're going to be working in a designated shortage area. Now, generally, the programs vary state by state, and some states will only open the program to primary care, but others will allow for specialists. So each state is a little bit different, and you have to work with, look at the state requirements depending on the state. But all states require a 3-year commitment, and that's mandatory for this program. You have to have a 3-year contract. Now, Health and Human Services is very similar, just like the other programs that I mentioned. It does require a 3-year commitment, and Health and Human Services is a little bit more narrow. They will not allow specialists into their program. So it's only primary care and general psychiatry. And you have to show that you will start or you will start the job within 12 months of finishing your residency program. And they have that requirement because they do not want specialists in this program. So it's really just for primary care, and it does require work in the shortage area. So there's no Flex 10 for HHS. You have to be in a shortage area for them. Now, they also have a research waiver program. And so this is important for if you're going to be an academic physician or going to work at an academic medical center, and you're doing a lot of research in addition to your clinical work, then this is a possibility for you. The waiver process is very difficult and it's very time consuming. Generally, for the research waiver side, we're looking at processing times in excess of 2 years. So once you finish your J1, in order to get a waiver, you probably are going to be here on an O1, let's say. So you can't get to the H1 unless you get that waiver first. And because the waivers are taking so long, really the practical only visa option for you is the O1. And Mary will talk about how difficult it is to get that. But this program is open if your research or what your research or clinical research is focused on some topic that the NIH is very interested in. So you have to link it to some specific projects that NIH is funding or that that NIH finds very important. And these applications are reviewed by subject matter experts. Some of the other types of waivers that we look at are reviewed by immigration, people in the immigration bureaucracy. But this particular waiver is reviewed by other researchers at NIH who will look at your accomplishments to see if it's worthy of granting you the waiver. So it is a difficult waiver to get, but if you are in academic medicine, then that can be something to look forward to. Now, there's also the hardship waiver. I mentioned that really quickly, but it's basically you have to show exceptional hardship on a U.S. citizen spouse or child, or permanent resident spouse or child. So it's not hardship to you, it's hardship to the U.S. citizen or permanent resident spouse or child. And it does need to be exceptional. So we have to show that there's something, something that's more than the average hardship someone would face if they had to go home for 2 years. So we have to show that your spouse or child would not be able to live without you in the US for those 2 years, and that your spouse or child would not be able to live in your home country for those 2 years. So generally it comes down to significant medical reasons why the spouse or some social aspect. So cultural differences that are really extreme, lack of opportunities for the US citizen or permanent resident. But we have to link it to some reason why they couldn't be here while you're back in your home country. So it's a difficult waiver to get, but it is available, especially for countries who are going through some turmoil right now. Now, the persecution waiver, we'll just mention it really briefly, but if you cannot go back to your home country because of your race, religion, or political opinion, or perceived political opinion, then you can apply for a waiver on this ground. And these waivers are a little bit different from the IGA waivers in that you first apply to US immigration. Then if immigration agrees that you have a good case to make, they send it to Department of State, who reviews your claim as well. If Department of State says no, then immigration will say no as well. So immigration, has to get a favorable recommendation from Department of State before they approve your waiver on this ground. So I went through all of these in detail because, most of you will have to go through the J1 program. But if you don't, then you don't have to worry about this waiver nonsense. It is really it's really time consuming, and if you can avoid it, that's the best thing. And Mary will lead us, hopefully, to show us about this, how to avoid it.
Great, thank you, Prasad. So I'm going to chat now about the H-1B process. So if some of you are lucky enough to find or match to a residency program that is offering the an H-1B, that's going to be it. It's kind of like you've won the lottery, to be honest. So we're going to chat about the criteria, the annual quota and timing for some institutions. Not all hospitals are going to be subject to this, and then some benefits and limitations. So generally speaking, the H-1B, the biggest benefit to the H-1B is it avoids the J-1 2-year home residency requirement, which I'm sure most of you, ideally would want to do. It does permit up to 6 years of work authorization in the United States. Now, that's also can be a con for physicians, because if you do a residency program during on an H-1B, you're going to be using up all of that time. And then you're not going to have much time at the end to switch to, another work visa and say an attending position and get through the green card process. So there's pros and cons to using the H-1B. It is ideal, but now you're going to start to cut into this, this 6-year max. And so you may have to almost look into sponsoring. You're seeing if a self-sponsored green card is an option, because you may not be able to, find a US employer to sponsor you for a green card before you start to run out of the H-1B time. So it's something to consider in advance. So it is the preferred way to transition to the green card or permanent resident status. That Madeline's going to talk about those options, because it allows for something called dual intent. As if most of you are on the F, or one day will be on the J, those are visa categories that have strict non-immigrant intent only. And what it means is, whether you realize it or not, every time you're applying for a visa at the embassy, or every time you're entering the United States, you're basically, expressing your non-immigrant intent to be here temporarily to finish out that program, and then you're going to return home. And so it just makes transitioning to the green card from those statuses more difficult. It's not impossible. You could do it, but you're going to have very heavy travel restrictions. You're going to have to coordinate your J waiver along with the green card, along with travel. It just makes for the process a little bit more difficult. So if you can get into H-1B status first and then into a green card, that would be ideal. You can, it allows for full-time or part-time, though most of you would probably be full-time in your situation. It does allow for concurrent employment, but separate petitions have to be filed for the employer. So if you're doing a residency, that's all you're going to be doing. You're going to just be working for one employer. But, just note that technically multiple employers can file for you, but it's not a status that just allows you to work for multiple employers at one time. Like, for example, F1 OPT, when you get your EAD card, if you are working on that, it's just a generic status and work authorization. And as long as you're working for some employer and doing a job that's related to your degree program, you can work by just notifying your school and updating your CVIS record. But an H-1B is very dependent on the employer, the worksite location, the job. So you need individual petitions for every single job. You can study part-time. So let's say you want to get like a master's of public health in the evenings or something like that. It is possible to do. I don't know if you'll have time to do it, but it is possible. And dependents are eligible for H-4 status. You do have up to a 60-day grace period should you lose your job or have to leave your, residency program, but it says you just know you may be eligible for up to 60 days. It's not a guarantee you'll get that full-time period. So let's chat about the limitations. As I mentioned, 6 years is a great amount of time to be on the H, but it's also a limit. So you've got to know that once you switch to H-1B, the clock starts ticking, and you really need to start planning out how are you going to transition off of this after 6 years. In very limited circumstances, you can extend beyond the 6 years if you're far enough along in a green card process. And you may not be far enough along in a green card or permanent resident process being sponsored by a US employer, but maybe a self-petitioned sponsorship would be, get you to where you can get H-1B extensions. And Madeline will talk a little bit more about that. But the 6-year clock does rewind, and you can start all over if you go abroad and you're outside the United States for 1 year. Then you can come back and get a new brand new 6 years. And you can recapture any time spent out of the United States. Not that you're going to have a ton of time for vacations during your employment, but any time that is physically spent abroad, doesn't have to be at your home country. It can be vacations or it can be at home, you can recapture that and you can add those days back on to the end of your 6 years. And sometimes you can extend it a couple more months, 6 months even, just depending on how much travel that you do. H4 spouses can get work authorization, but in very limited circumstances. You really have to be pretty far along in the green card process or be in a backlog category, for example, if you're from India or China, to be eligible for employment authorization. So just something to consider that, if you have a spouse and you're deciding between an H-1B and a J, there's pros and cons to that. A J-2 spouse can apply for work authorization and work. However, if you're going to be subject to the J-1 home residency requirement, so will your spouse. They will automatically be subject to the J-1 just by being a J-2 dependent. So they get the benefit of working during your residency, but now you're both going to be subject to the J-1 home residency requirement. If you waive it and you're married, it gets waived for them as well. So they can be added on to that. So just more considerations to make this even more complex of a decision for you. But let's talk about a few requirements that are specific to physicians for the H-1B. In general, an H-1B, as long as you have a bachelor's degree in a specialty or field that's related to your job, that's, for the most part, everybody else in other industries, that's all that they need to prove. But for physicians, there are a few additional requirements that you have to make sure that you have. One is that you have all 3 steps of the USMLE. I highly doubt any of you on this qualify for this exception, but some physicians who have passed older exams, like steps 1 and 2 of the FLEX, or all 3 parts of the National Board of Medical Examiners, they can meet this requirement, but for most of you, you're going to have to pass all 3 steps of the USMLE. I'm going to give an exception to this rule in a second. You also have to prove that you have ECFMG certification. So that if you're going to be doing anything clinical, patient care, you're going to have to make sure that you have passed the English proficiency exams. Then there's licensure. That's always sort of a complicated issue. The timing of it is just right. Many states, it's kind of a catch-22. Some states will not grant a license until you have obtained a social security number. And if you haven't been in the United States long enough to have obtained one through some other means like OPT or a J-1 or something like that, then if you can't get a social security number until you have a visa, like an H-1B work authorization, then you can't get licensure and you can't get an H-1B. It's this weird sort of catch-22. But there is this obscure memo from immigration that says, if you can get a letter from the state medical board stating that they can't issue your final license until you've gotten your H-1B visa, gotten your social security number, but they will once you do, immigration can go ahead and approve the H-1B petition. So they'll only issue it for 1 year, and then your hospital is going to have to extend that. But it is sort of possible to get through that hurdle. But you're going to have to, within your hospital, you're going to be working probably with an immigration department who's going to handle your H-1B petition, but they're also going to have you work with like the licensing department to deal with that. There's other credentialing departments. So at some point when you're going through the H-1B process, you're going to be working with multiple departments, sometimes an outside immigration counsel, who are all doing different little steps and different little pieces. And it's good to make sure you sort of have them all looped in, because if something's going to delay licensure, if something's going to delay any sort of credentialing, it's going to delay the H-1B as well. So get everybody in the loop as soon as you can in the process. If you have not passed your USMLEs, or you're not going to, there is an option for qualifying as a physician of international renown. Now, the tricky part about this category is that it's not really well defined what that means in the regulation. So pretty much the only definition we have to work with is you're widely acclaimed and highly honored in the field of medicine within 1 or more countries, so long as achievements leading to national renown are comparable to that which would result in national renown in the United States. And that's it. There's other visa categories like the O1 I'm going to talk about in a few minutes that have very strict criteria that you have to meet. And it's almost, somewhat easier because where what standards you got to prove. This is pretty much all the guidance we have. So this is the type of evidence that we submit when we are preparing one of these petitions. So if you've received a national award, or even frankly, an international award, that's great. If you've authored scholarly publications, or if you've done some sort of research during other types, whether it's an MD or residency or anything like that, would be great. If you've received any media attention, even if you're not named in the media, but maybe your article is, or the project you're working on is, and we can make a link that you were part of that team or the solo author. If you've worked, had a critical or leading role at an organization with a distinguished reputation, if you've spoken, been a panelist, judged the work of others, whether it's for a journal, whether it's a technical program committee at a conference, all of these things, they're very similar criteria to the O1 extraordinary ability I'm going to talk about, but you don't have to say meet 3 from this list. You just have to kind of prove in the totality you are considered, you're considered, you are renowned, but it can't just be local within your country. It can't just be local within your hospital. You have to show that, if people are citing to your work, where are the citations coming from? Are they coming all from your country, France, or are people from around the world citing you? So is the conferences you're presenting at international conferences, or just local, regional, city conferences? So those are the types of things that we look at in preparing this type of H. There is something you may have heard about, that there's this annual quota or cap or limit to the number of H-1Bs that are granted every single year. And that's true, but there are exceptions to that. So generally speaking, there are cap subject employers, and the cap just means the limit. It's capped out at a certain number, 85,000 new H-1B visas. So it's 65,000 for individuals with a bachelor's degree, and an additional 20,000 for individuals with a U.S. master's degree or higher, like a U.S. MD. Visas become available every October 1st, but they run a lottery for these in March. We're actually right in the middle of the H-1B lottery this week. And what it is we register everybody who is going to be employed by a cap subject employer in sort of an advanced lottery system. And so we're entering people into this online database. It doesn't take a lot of data points, your name, your passport, your company information, but it's not you who is registering. It's your employer who is registering you. The H-1B is not really your petition. It's your employer's petition for you. You're just the beneficiary. And so immigration will open up this lottery for about 3 weeks in March. Everybody registers. Last year, there was about 480,000 individuals who entered this lottery. And then they run both lotteries, the regular bachelor's cap, and then those who are selected that have a U.S. master's or higher go into the master's cap. They do this the last week of March. And by the end of March, your employer or their lawyer knows if you've been selected or not. If selected, you can then file an H-1B petition between April 1st and June 30th of every year. And just because you've been selected in the H-1B lottery does not mean you automatically get an H. You still have to file the petition and qualify. But luckily, most physician positions do qualify as a specialty occupation because they do require a degree in MD in a very specific field. But if for some reason you're going to use an H-1B for a research fellowship or something like that, and you're taking a break from your program or your track to being a physician, and you're just going to do research for a little bit, your H-1B, you're going to have to prove that the research you're doing requires the degree that you have. So just be prepared that it's not a guarantee that you get this. However, not all of you have to worry about this lottery. In fact, only cap subject employers, private employers do. There are a lot of exceptions to those in companies that qualify. And the biggest one is that you are going to be employed by a college or university. But really, this next one is that you're going to be employed by a nonprofit closely affiliated with a college or university. And that's where a lot of hospitals fall into it. Some hospitals are private hospitals, and they're going to be subject to the annual lottery. But a lot of hospitals are affiliated, have very strong written affiliation agreements with a local medical school. So for example, in Boston, we have, countless hospitals here, Mass General Hospital, Brigham and Women, Beth Israel, they're all affiliated with Harvard Medical School. They have an affiliation agreement since like 1945 or something like that. And so they are exempt from the annual lottery. So they can apply for H-1Bs year round. You don't have to be registered and you can skip right over it. So if you are one day going through the H-1B process, it's important, or considering jobs, it's important to sort of check to see, is this a CAP exempt hospital because they're affiliated with a medical school, or is it going to be CAP subject because they're a private hospital? Because it can take, with 485,000 registrants and only 80,000 H-1Bs or 85,000 H-1Bs issued every year, it's like a 35% chance. And so you only have 1 year of optional practical training. If you're doing this from F, you only have 1 year to actually win the lottery. You're gonna have to win it in that very first year. So just keep all of that in mind when you're going through the process. Some of you might actually qualify for a visa called the O1 Person of Extraordinary Ability. And it may sound very similar to the H-1B of international renown. In my opinion, it's a harder standard to reach. I don't tend to get a ton of pushback and requests for evidence on my H's of international renown, but O1s of extraordinary ability, really you have to be in the very top percentage of your field. Now, the great thing about the O1 is that if you are subject to the 2-year home residency requirement, and you're going to have to go through, a complex waiver process, a Conrad 30 waiver, an HHS waiver that could take a year or two to go through that process. You could work on an O1 extraordinary ability visa in the meantime. You're not eligible to change status to H-1B until you have a J waiver, but you can but you can apply for an O1. You can't do the change of status from within the United States. You can just apply for, or be sponsored for the petition, but you would have to leave the United States, apply for the O1 visa at a US embassy, and come in to activate your status. So it is something that these visas take a lot of time, not only to prepare all the evidence that I'm going to go through, but then actually leave the country, get a visa appointment, and get back in, because some embassies are backlogged certain times of years, but some embassies are just frankly backlogged still because of COVID. So, you just have to make sure that you've allotted enough time to get this O before whatever position start date is that you have. So again, this is for someone who has extraordinary ability. And to be honest, this is going to work better for someone who's done a little research during their MD. Maybe they took some time off and did a fellowship, and they've got some publications that have resulted from this. So, you must prove that you have sustained national or international claim, and you have a high expertise that show that you are a small percentage of your field. So really you have to prove 3 of these criteria from this list of about 9. And very similar to the ones I've kind of chatted about for the H of international renown. But again, a national or international award, it should not really be academic related. It needs to be open to everybody and not just one university. Membership in an association that demands outstanding achievement. And sometimes you won't get those membership until you're a little further along in your career. So we don't prove this one often for individuals at your level. To be honest, the example they give is the National Academy of Sciences. Now, that's not really the only membership that they'll accept, but usually it's not a pay your dues membership. It's you've been nominated and been accepted and gone through a rigorous selection process. You've published in scholarly publications, you've judged the work of others, through peer review, or you've been an editor of a journal. You have original scientific or scholarly contributions of major significance. So what this means is that you're having a widespread impact on the field. So whatever you're doing has been highly cited. It's been highlighted in the media. Other physicians maybe are using this technique that you've developed, or this protocol that maybe hospitals are using. So you can't just be a contribution. It really needs to be of major significance. Now, I don't want to scare anybody away. We get plenty of physicians O1s. So, but I just want to let you know that it's just not available to everyone. There needs to be some sort of prior life where you were probably a researcher and doing this side of kind of publications and presentations at conferences and peer review activities. So it's something to think about now. how can you build up your CV now so that if you need to use an O1, because you've got a match at a J program and you're not going to be able to do a waiver right away and an H isn't going to be an option, maybe think about building your CV now. Get in on as many research activities or projects that you can with your colleagues. Get published as much as you can. Do any peer review activities, speak at conferences, whatever you can do. Put yourself out there and start to build up your CV now so that when you go talk to a future employer, you have something to kind of present as an option. But the key to the O is that it's not that you just meet those three criteria. It's really the totality of the evidence. And the O digs into the second layer of analysis that you need to prove. What was your journal rankings? Were you first author or just contributing author? What's the H impact factor? Were you doing this research or employment at one of the top hospitals or leading institutions? Were you, when you were doing peer review for journals, what were the rankings of those journals? When you got citations, what were the rankings of the journals that were publishing the work that was citing to you? It's this whole second layer of analysis that really makes for a successful O1. So just sort of keep that in mind. And the last one I want to talk about, as Prasad mentioned early on, this may not actually be an option for a lot of you, but it may come up in limited circumstances. A TN is a special visa for Canadians and Mexicans, and it does not allow for any clinical activity. It's research only, but I have had in just very limited circumstances where someone had to go on a TN for a while. And so they stopped doing clinical and they just did research only. So if, and who knows where your career path will take you. One day you might want to stop doing clinical and take on some research or a fellowship or something like that. And you, if you're from Canada or Mexico, can get this TN visa. There's no quota for it. You can get it for up to 3 years at a time. It does require an employer to sponsor you, but the great thing about it is you don't have to go through this long, complicated, expensive application process with US citizenship and immigration first, like an H or an O. Instead, if you're Canadian, you can apply right directly at the border. If you are a Mexican national, you just apply directly at an embassy because you need a visa. So they can be quick and easy to get and cost effective. So basically just quick summarizing the alternatives to a J1, if you're not taking the J path, is, if you did take the J and you're subject to the 212E, you're not going to be able to do an H1B visa until you've had it waived. Instead, you could potentially do an O1 extraordinary ability until the waiver is completed. If you don't have your USMLEs, you haven't passed all 3 steps, you can do an H1B physician of international renown. And if you have no license, right, and you're from Canada or Mexico and you're working on the license, maybe you can do research only for a little bit and a TN. And then once you get your license, you can transition to an H1B. So these are all your kind of non-immigrant visa options. But once you're now ready to transition to permanent residency or a green card, we want to explore those options for you. So I'm going to let Madeline jump in and cover those.
Thanks so much, Mary and Prasad. So I know it sounds pretty daunting, right, this path. But in terms of permanent residence, I'll try to respond to some of the questions that asked how to transition from H1B to green card. Because if you're a J1 residency, you're not going to really be able to jump right to a green card from J1. So you'd have to take care of that waiver and then transition to an H1B, because that's really the best platform to go from H1 to green card. And so I'm going to talk about the employment-based system of green cards of permanent residence. I'll touch upon family-based. And we like to mention the diversity lottery that is available to certain countries where the government feels there's still low immigration. That opens up every October 1. It's run through the Department of State and it's free. However, there are specific instructions that you would have to follow through the Department of State. But once, if you are selected, again, this lottery, it really is a lottery, you have to gain your green card within that fiscal year. So I'm not going to get too much into it more than that, but that could be an option in the future if you're from a particular country that can participate in the lottery. Investment, this you may have heard, is that $1 million EB-5 green card. So if you're very wealthy, you got your H-1B and you want to go that route and you want to start a business, that just mention it. And then as Prasad mentioned, there's humanitarian ways of immigrating. If you're fearful of returning home, you're here as a refugee. And then others come up, as Prasad mentioned, it's dynamic, and you could qualify at some later time for other programs. So in terms of the employment-based categories, it's divided by preference categories. So EB-1 is the highest priority category, and that's subdivided into 3 categories: persons of extraordinary ability, which is very similar to what Mary was talking about, the O1. Outstanding professors and researchers. If you're maybe in your future a physician researcher and you're being sponsored by an employer and you will be carrying out research in addition to your clinical duties, that could be a category for you. EB-1C is really not relevant to this program, so I won't talk about it. It's for business people. EB-2, this is the most common, we would say, for physicians. Professionals with an advanced degree, of course, an MD, or people with exceptional ability. There are 2 categories within that: the national interest waiver, which I'll talk about it in some detail, and PERM, which is the major way that people immigrate. And then the others are lower level E3, people with bachelor's or skilled workers. And the categories there are 2 categories where you can self-sponsor. You don't need an employer to sponsor you. Those are EB-1 extraordinary ability, EB-1A, and and the national interest waiver. Typically, though, the government's major concern is that giving you a green card doesn't take a job away from a U.S. worker. So that is where PERM comes in, which I'll talk about next. And that's just the system that the employer has to follow to test the U.S. job market, to show the government that there is no U.S. worker that you're taking a job away from. So before I get into that, though, we have to talk about the category and country backlogs, because someone asked, how long will this take? And it really does vary by nationality. So as Mary mentioned, there's a quota for the H-1Bs, 85,000. There is a quota every year for green cards, for employment-based green cards, roughly at 140,000 every year. It's divided by those categories that I mentioned. Highest preference is the EB-1, and then on down the line. But backlogs can occur, and they occur because certain countries use more of those. There's more applicants from certain nationalities that are using or requesting those green card numbers every year, so backlogs develop. And so people are put in a queue. And so you're doing the right thing attending one of these programs because you're trying to understand timing. In terms of how long it will take, it's governed by the Visa Bulletin. And the Visa Bulletin is issued every month by the US Department of State. So you can actually, of course, Google this, and you can get on their mailing list. And it's published a couple of weeks ahead of the next month. So already, we're already in March, maybe in another week or so, they'll publish April, the Department of State. So as you can see, this is a very simplified version of the Visa Bulletin. On the left-hand side is the major categories, EB-1, EB-2, EB-3, and then it's divided by nationality. So if you see all other, that just means if you're not specified in the other columns, you fall in under all other. And to give you an idea of how long it takes for certain nationalities, so for a physician from India, it's typically EB-2, which is MD or higher, but MD. And it's a terribly long wait, as you can see, October 8th, 2011. So that means you would have had to trigger the start of your green card application, and that date carries with you throughout the process. And then you have to check the Visa Bulletin. And if your date is current, meaning there is no wait, there's a number available for you, then you can file the green card. But if there's a date specific, then your date that's your place in line has to be on or before that date before you can file a green card. So this is a snapshot of the typical process. So say you're on H-1B status, you're in a good situation with your employer and they want to sponsor you, they're willing to sponsor you. The first step is typically labor certification, where the employer files certain documents with the Department of Labor to show that it tested the US job market. Once that labor certification is approved by the Department of Labor, then the employer can move to the second step, and that is filing an immigrant visa petition on your behalf. But I should mention, when the employer files step one, the date that it's filed, that's your place in that visa bulletin that I mentioned. So say today, an employer, March 6, 2023, filed step one on your behalf. That's the date that carries you on that visa bulletin. So step one's approved, then the employer files step two, which is relatively straightforward. It's just some paperwork with the government. And then once that's approved, you have to check the visa bulletin to see if you can actually file a green card. And that's where the brakes are pulled for some people, say from India. They can't file step three because there's that backlog. And so but they're allowed to continue on H-1B status even beyond 6 years if the employer, say, filed step one before the end of the 5th year of H-1B usage. So that's why when Mary mentioned that if you have luck and you have an employer that's willing to allow you to use your residency time on H-1B, that will eat up 3 years, right? So as you can see, these steps take a long time. So when you're looking into the future and you're maybe going to be sponsored for H1, you should also ask them about policy, potentially ask them about sponsorship, because it is very important in terms of timing. Now, in terms of the labor certification process, it requires an offer of full-time job. I don't think that's an issue here for a physician. And as I mentioned, there's certain regulatory requirements that the employer must follow to test the US job market, prevailing wage issues. And it really can take up to 2 years just to get through step one. And then there's those backlogs that I showed you through the visa bulletin for people, particularly from India and China, that face tremendous, India especially, tremendous backlogs. So to skip labor certification, obviously it cuts a lot of time. Some people that are of the caliber that Mary mentioned under the O1 can self-sponsor, and they don't need an employer to sponsor them under EB1A. And I won't get into all the criteria because it really is almost identical to what Mary talked about. It's all those criteria, publications, and all those documented evidence of extraordinary ability that you have to present to the government. But the great thing is, if you qualify, you don't have to worry about an employer sponsoring you. You can file it on your own. There is premium processing. They'll adjudicate it within 15 days, but it is the most difficult category, of course. And as I mentioned before, if you are sponsored, you're working at a hospital and they're willing to, you're doing research as part of your job, you could be sponsored for EB1B. And our office, we file many of these. It's a very successful category. You need an offer of employment. You do have to have sponsorship, either by a university, college, offering you tenure track if you want to teach after your education, or if it's an organization that employs at least 3 full-time researchers. You have to demonstrate at least 3 years of teaching or research experience, and you have to show 2, not 3, as Mary mentioned, of the extraordinary ability, but at least 2 of these criteria. And as you can see, they're very similar to the criteria mentioned under extraordinary ability, but you only need 2 and not 3. And I would say these are probably 90% successful in terms of adjudication. So, but you do have to have an employer sponsoring you. And then the other category where you can self-sponsor, where you also don't need an employer, is the national interest waiver. You have to have a master's or higher, for example, the MD. You can skip over that labor certification that's taking currently 2 years. You have to demonstrate, though, these 3 areas: that your endeavor has substantial merit and national importance. Usually you have to show statistics, things about your field where you're going to, you've already carried forth, say, research in that area, because that demonstrates you're well positioned to carry forth the endeavor. And then on balance, it makes sense to skip labor certification, because a newspaper ad or advertisements is not going to find someone like you. Examples of work of national interest, these are pretty typical. Improving healthcare, say you're a research, you've done research in cancer research, for example, but not just medical, improving working conditions, wages, housing, various subject areas that could be examples of an endeavor of national interest. So there's another category also specific to physicians called the Physician National Interest Waiver. And as Prasad mentioned, this does require an employer to sponsor you. And if you're already, say what Prasad had mentioned for the J1 waiver, where you have to serve 3 years in a medically underserved area. If you agree to serve 5 years in a medically underserved area, in primary care or even a specialized medical area, as long as you're working in a underserved area and you have evidence of that from, say, the Department of Public Health of the state that you're in, it can be filed at any time. The petition can be filed by an employer at any time, and you have to show 5 years of service before you can file the green card. So the petition is filed by the employer with a letter from the Department of Public Health. And the 3 years that say you've already started for the J1 waiver counts toward the 5 years. So that work can be done ahead. The petition can be filed, and as soon as the 5 years are over, you can file the green card, or it can even be held in abeyance by immigration. But again, to file the green card, you have to be current on the visa bulletin. So I'll touch upon family-based immigration. Sometimes we'll get someone asking us, well, gee, there's all these options you just outlined and my head's spinning, but I'm actually, in love with the US citizen. Would that be easier? And, of course it would be much easier because if you're sponsored by a US citizen, you're called an immediate relative. A citizen can sponsor a parent, a spouse, and unmarried minor children, also fiancés. So there is no quota, as I mentioned before, that staggering weight for Indian nationals and Chinese nationals. For people married to a US citizen, there's no quota. It's called the immediate relative category. It's just the paperwork processing time. But then there are other categories where there is a quota. There's a whole nother section on the visa bulletin for family-based immigration. So if you're married, say, to a green card holder, you could face a quota. Sisters and brothers of citizens face a huge quota, 20 to 30 years even. And so these are some of the other categories, but same-sex marriage is permitted now. It's been recognized for over 5 years by the US government. And children, of course, can also be sponsored by citizens. So that's the end of our presentation. That's touching upon green cards. But all the time that you're in the US, the timing is so critical because as Prasad and Mary talked about, these to get to the point of H-1B or finishing your medical training can eat up a lot of time. And then you still face working toward the green card. That you can extend H-1B if you're far along enough in the green card process, and that will allow, that's why some physicians are on H-1B for 5, 6, 10 years until they get the green card. So that, I'm wrapping up our presentation. I see there's some more questions in the chat, and I'll let Kevin talk about those and any new ones that you may have. Thank you.
Thank you so much, Ms. Welsh, Mr. Desai, and Ms. Cronin. This is extremely helpful and extremely informative. I really, just want to say appreciate you all. And we do have a pretty huge backlog of questions here too. So I'm going to read them all, and if you guys want to chime in, I'll try to be I'm hoping we can have more time for everything, but let's see how far we can go. So the first question is, if we go to medical school in the Caribbean, and I'm not a US citizen, which visa would I need to do clinical rotations in the US? The schools let students do rotations in the US.
So yeah, so you can observe and do clerkships while you're an MD student, but once you finish your studies and you're in a residency program overseas, then you can, then you would need an H1 or some other visa if you're going to have clinical practice. But if you're a student overseas, then you can have elective clerkships on the B1, B2 visa, which is the tourist visa. But one thing, Kevin, did you turn off the recording because we're in the
Oh, right.
question and
Yes.
Q&A?
I'm going to turn off the recording. Sorry. Thanks
Thank
for
you.
reminding me.